So, first things first, let's talk about the LPE1 form that was revised as of January this year. There are now some additional questions that the LPE1 deals with, which I'm going to explore in a moment or two. If a landlord completes an LPE1, a question that's been put to me is, what is the position with regard to the landlord? Would the landlord be potentially liable for misrepresentation? Answer, yes. Would the landlord commit a criminal offence? Answer, probably not. The landlord would potentially commit a criminal offence if the landlord produced a landlord certificate that was defective, but wouldn't necessarily generate criminality with regard to a defective reply in connection with LPE1, unless the landlord deliberately lied with regard to the provision information. What should you do if you're acting for a landlord, a seller, or a buyer in a leasehold transaction? I think you need to be more careful than ever about scoping your retainer. And let's just stop there for a moment or two and have a think about it. If you're acting for a seller, I would be scoping the retainer to advise the client that I am unable to proffer advice or assistance with regard to the completion of a leaseholder deed of certificate if such a document is required. I would deal with a leaseholder deed certificate in the same way that I would deal with a seller completing a TA form, advising the seller to complete the form, advising the seller to ensure that all the information is accurate, warning the seller that if the information isn't accurate, it could have drastic consequences for the seller with regard to misrepresentation claim. If you're acting for the landlord, again, same position with regard to the production of a landlord certificate. A landlord certificate is potentially a very complex document. So complex that I know already that some landlords are saying we're not going to produce landlord certificates in connection with buildings that are potentially protected under the Act, because in doing so we're going to spend so much time gathering information to produce a certificate that it's not cost effective to do so. And secondly, we don't want to share commercially sensitive information with the world at large concerning our business. So some landlords are saying we're not going to produce a landlord certificate, even though that we know by default a relevant lease in a relevant building will mean the leaseholder is protected under the Act. If you're acting for a buyer, I think you have to be so careful about scoping the retainer so the buyer understands that the buyer and you are reliant on information from third parties, the LPE1, the landlord certificate, the leaseholder deed of certificate, and if those documents contain incorrect information, it may be that any advice or explanation that you provide as to whether a building or a lease is protected by the Act or isn't is defective. I think, as I mentioned on slide, we've got to be careful about scoping the retainer and also when acting for a buyer, what we say in our report on Title 2. The client needs to understand that we're not fire safety or building safety experts. The clients need to understand that the Building Safety Act 2022 is exceedingly complicated, and that in order to give a client proper full advice with regard to the implications of the Act and the application of the Act in connection with the protection of a buyer, the amount of work that would be needed to be done to ensure that the client and you were safe in the knowledge that the Act applied or it didn't apply would mean that you'd have to charge an awful lot more for the work that you're doing.